let's shift to touching on domestic violence. Most people are aware of the Duluth model. The Duluth model is basically the premise nationally that says you always are to believe the victim, and therefore courts respond accordingly with that. Let's kind of dovetail domestic violence in with the conversation to also recognize the importance of judicial discretion. So based on what your experiences are, let's change the topic a little bit here.
Well, it should take a lot more than the mere mention of domestic violence for a family law judge who's making that custody determination to have that mere mention sway his or her decision. All too often, one parent will either in the family law case or in a separate petition for an injunction for protection against domestic violence be able to sway that judge regardless. This is before there's any actual finding of preponderance of evidence or clear and convincing, or better yet, a criminal conviction. There needs to be in the statute for 50-50 a fairly tight, high standard of proof for that domestic violence exception to override the 50-50 presumption. Because, like with the example of the Kentucky law that Jeremy talked about yesterday with Jeff, that practically invites unsubstantiated domestic violence allegations. You might as well just say to the domestic violence industry, hey, here's your opportunity to overturn just about every 50-50 parenting plan, because anybody can be going through a domestic violence case. That is so vague. At minimum, for purposes of lawyers operating in family law cases, we'd be more comfortable, I would be more comfortable in some kind of clear and convincing evidence of domestic violence before the 50-50 presumption is overturned. And it's not just saying, well, I called 911 one time, the police came out, there's a police report. No, there has to be 70% more likelihood on the facts that domestic violence actually occurred. So yeah, unfortunately, domestic violence is used for the wrong reasons too often in family law.
And here's how I've seen it play out. Missouri has a statute called the Abuse Act, and it's known among the lawyers as the most abused act on the books because of these false allegations. Making it worse, once abuse has been alleged, the court, it's mandated in statute, the court shall appoint a guardian ad litem. Making it even worse, the allegation of abuse doesn't even have to be made under oath, and it doesn't even have to be made by the party, the parent. So I had an attorney once just write out a one-line due to the abuse of dad. After I pulled myself down from the ceiling, I said to the judge, this isn't even under oath, that's not even made by the party, none of it has to be under the Missouri statute. And this of course came after we'd already settled the case, and we just didn't have signatures on the final paperwork. What's happened then is the abuse gets alleged. Right away the judge appoints a guardian ad litem. Guardian ad litem comes in and says, whoa, I want money, and then I need to do an investigation, and the whole point is to slow everything down. Keep the other parent, excuse me, under the microscope for as long as you possibly can, because who can survive under a microscope for another 12, 18 months? So, and I'd be interested to get your point on this. I haven't had to sort of follow it through yet in the case, but my instinct then is as soon as I see an allegation of, in an answer or in a motion or something, I want to file a snap notice of deposition and get that party who's making those allegations under oath in a dep in 7 days, or whatever your state's minimum is, before they have more time to round out the story of their allegations, and before they have more time to consult with their attorney about how they're going to prolong this entire thing, because that's usually what it is. Because otherwise, now I've also had genuine issues of abuse, and in genuine cases I've had where there are allegations of abuse, I have a police report, I have a DFS report, I have documentation before it's come around, so you can spot them coming out. But that's the object, and that's how I've handled them on a limited basis anyways.
Wonderful question again about domestic violence, and these two attorneys are talking about being on the receiving end of accusations. as what's called the silver bullet in the legal field. You throw out that accusation and it throws the whole case into a tailspin in favor of the accuser, if it's false. I'd like to go back to the other side again of domestic violence and back to parent alienation and it weaves back into the custody and equal custody and the rebuttable presumption of equal custody. And again, I beg you to go to your legislators with the science, not just your own stories, because they'll be skeptical of your own stories. But it'll be much harder for them to be skeptical of a growing community of PhDs and PsyDs. And that's why I'll quote again Dr. Edward Crook, K-R-U-K. He says, custody and legal possession of a child are fertile ground for abusive parents to act at will against the targeted parent. And here's the child protection issue. Witnessing such acts of violence by children constitute a serious form of emotional child abuse. So those accusations actually are an example of emotional abuse. So what I'm saying is, in this environment of Me Too, not that there's anything wrong with Me Too, but people are very sensitive to victims of abuse. What I'm suggesting is, you are victims of domestic violence in the most classic definition of it. So for example, Dr. Craig Childress says, the professional term for domestic violence is intimate partner violence. And the reason you're targeted is because, the reason you're called targeted parents is because you are being targeted for intimate partner emotional abuse. It's emotional violence. And your ex is using the child as a weapon. Your child is being literally used as a real weapon of revenge and retaliation against you for the divorce. That's what I beg you to tell your legislators. And especially, it's happening to mothers too. And my theory, my hypothesis is that people will be even more receptive if mothers come in and say, we're being abused. Emotional domestic violence. It can be a fist, it could be a plate, it can be a gun, but it could be literally a child as a weapon.
So the Duluth model is this antiquated model that has this power wheel that, and I'm going to just summarize it, this is why men abuse. It's all about control, and it's geared towards men. So if you Google the Duluth model, you will see probably more criticisms about the Duluth model than you will see people now supporting the Duluth model. The problem with the Duluth model, okay, that again talks about how men are abusive and men are power hungry. You look at their power wheel, it's all about men, is a lot of judges in a lot of domestic violence industries are still being trained under the Duluth model. Right? So that's a problem. So some federal funding is contingent upon training in the Duluth model. So there's a lot of studies out there. We all know that men are victims of domestic violence at just as high rates as women. Women tend to, women are just, by nature, we're not as strong as men are, but women tend to start fights. Women will start the arguments. Some women get bruises because men try to, all I was trying to do was hold her, get her away from me, right? So when the allegations come up, I can tell you that, and two lawyers sitting back there that can tell you. We have several clients who would probably be in jail had they not been recording the confrontation at the time that they were in it. So, but that aside, judges and the domestic violence industry, they're still being trained in this old Duluth model. So we have to get away from this sexist bias mindset that men are toxic and they're abusers, and women are victims in need of protection. I am not in need of protection. I'm not a victim. I've never been a victim. I may have had people even in my childhood do things to me that were horrible, but I'm no one's victim. As I sit here today, I'm no one's victim. I don't need anyone to categorize me as that, so I find it very offensive as a woman. But this Duluth model, the government does not need to have funding based upon this model, because so we have some judges going in there. They know where their funding comes from. The judges know where their funding comes from. The domestic violence industry definitely knows where their funding comes from. So the Duluth model is actually working against everything we're trying to do. And it's against all the research that has come out since then. So if any of you don't know about the Duluth model, I encourage you to look it up, read the criticisms about it. And it's scary to know that our judges rather, are still being trained in the Duluth model.
One more comment about that, and I've been urging you to go to your legislators. Before the panel, Melissa mentioned the American Psychological Association. I feel that, and she mentioned the problem is that the courts won't change, the legislators won't change because the professionals won't change their own standards. So unfortunately, but it's a wonderful opportunity, is I urge you not only to go to your legislator, but go to the American Psychological Association. Go to the CDC, who runs the survey for intimate partner violence. Urge them, educate them, talk to them, and if they start changing, then it will start to ripple. So it's not just the legislator.